So here are my takeaways from one of my favorite subjects, which is licensing defense. Hire an attorney. If you are notified that a complaint has been filed against your license, your career is at stake and you need to defend your career. And you need to hire an attorney so you can have the best defense possible. You want to get your side of the story told, but you want to tell it in a way that's protective of you, truthful, but protective of you, and an attorney is the best way to do that. Now, you just don't want to hire any attorney. You should hire an attorney who specializes in professional license defense, because there are a lot of different considerations when defending someone in a license defense case. And I'll give you just a brief example. I talked to you earlier about private consent orders and how those orders are only private in the sense that they can't be accessible through the Georgia Board of Nursing's website. An attorney who specializes in license defense knows that that private order can be accessible in other databases, and they need to advise you of that when you're trying to make a decision on whether you want to sign the order, if you want to go to a hearing, or how you want to proceed. Number 2, please get a license protection insurance policy. There are insurance policies out there that cost less than $200 a year that will pay for a lawyer to defend you up to $25,000 in legal fees. If you don't have a license protection insurance policy and you want to hire an attorney, you're going to have to pay those fees yourself. So having a license protection insurance policy minimizes your stress because you at least don't have to pay for an attorney to defend you. You don't have to worry about that. Now, a question that comes up a lot is, my employer, they provide insurance that protects me if something happens on the job. Well, that is true in most cases. In most cases, your employer has a medical malpractice insurance policy that will pay for your defense, your legal defense, if you're sued for medical malpractice. That's pretty true in most cases. However, those policies usually do not have any provision that will pay for you to have an attorney to represent you if a complaint is filed against your license. So that is really on you and your responsibility to have a license protection policy that will cover you if a complaint is filed against your license. As we discussed before, you're going to go ahead and do that exercise that I gave you earlier. You're going to read the Nurse Practice Act. You're going to go to Georgia Board of Nursing's website, pull it up, and find that section that covers unprofessional conduct that I told you was about 3 to 4 pages long. You're going to read that. That's an exercise I want you to walk away with. And I'm not giving you a lot of guidance on that because I want you to remember where you found it, what you read, so just in case you ever need it again, you know where to find it. Be familiar with the Nurse Practice Act. If questions come up in your practice, refer to it, read it. Document appropriately. We talked about that in the context of medical malpractice. That's also very important in the context of license defense because some license complaints allege substandard care. Some license complaints allege something related to your care of the patient, even if it's not substandard care, something related to your interaction with the patient. It's very important for you to document appropriately. Now, we talked about this earlier in the context of medical malpractice, but it's also very important in the context of license defense. Sometimes the allegations in a complaint are related to your care of the patient, substandard care, or sometimes related to your interactions with the patient. For example, say if you have a patient that has been violent towards you. You want to be very detailed in your documentation about the type of violence that you're encountering. Kicking, biting, spitting, punching, pushing, pulling your hair, sexual abuse, anything. You want to make sure that you're very detailed about what that patient's behavior entails. Because if you report it to the board due to an interaction with that patient that someone deemed inappropriate, you're able to have documentation that clearly outlines your interactions with that violent patient and what that violent patient was doing in detail. And it's not just something that you're saying, but it's something that you documented in real time. It would greatly help you in your defense. You want to make sure that you're following your facility's policies and procedures. That is not only important in the context of medical malpractice, but it's also very important in the context of licensed complaints. If a complaint is filed against you alleging unprofessional conduct, and there is a policy that your employer has that relates to that conduct, the board will consider that policy and compare it against the conduct that's being alleged to determine if you followed the policy or not. So you want to be very familiar with your hospital's policies and procedures, your employer's policies and procedures, so you can follow them in your practice. Invoke the chain of command when you need to. Your facility has a chain of command policy, and that policy is in place for situations in which something is happening and you're uplifting that concern to the nurse manager, the charge nurse, or someone within that chain of command, and you feel that you need to go higher to really uplift that concern. So please read your facility's policy about chain of command and use it when you need to. Be very mindful of social media. We talked about unprofessional conduct, and you're going to do that exercise where you pull up the Nurse Practice Act on the Georgia Board of Nursing's website. You're going to read the section on unprofessional conduct and their definition of that, so you can be familiar with what the definition is. And you're going to find out that social media, which obviously happens most times outside the workplace, things that you post can result in a board complaint against you. Examples: you know that you can't post sensitive patient information. You cannot violate HIPAA. You can't go within Facebook or Instagram, YouTube or TikTok and talk about patients that you care for, because you are then violating HIPAA and subjecting yourself to a board complaint.